Hey, happy Wednesday, everybody. Welcome to Charlas con Lina, Chats with Lina. Um, Happy to be here again. I haven't had a Facebook Live in a couple of weeks because I was out on vacation, but still thinking about all the information that I could bring to you guys, things that are, questions that people ask me that I can't answer because, as you know, I'm an employment attorney, and sometimes people think that attorneys do everything, and that's just, it's not the case. I'm sort of a one-trick pony. I do employment law, and but I have friends who do other kinds of laws, and I've been bringing those people over to the show to talk about, you know, things that people should know about. So a couple of weeks ago, or I think a month ago, I had my friend Tonil Ragland, who is a corporate attorney, to talk about business formations. We talked a little bit about LLCs. We talked a little bit about, if you're going to open a business, what sort of business corporate formation would be good to have, et cetera, et cetera. So we also touched a little bit there on intellectual property, right? And so today I am very pleased to have Sharon Khan, who is an intellectual property attorney with Perdalis and Nojavica. Perdalis and Nojavica are, Joe Nojavica and Tasso Perdalis, who are, very good colleagues, good friends of mine for a long time. And so I asked Sharon to come on the show to answer some questions that I've been asked, this past month. My office has been, we've been receiving calls, which, by the way, I'm forwarding to Tasso Perdalis, on trademarks and copyrights and and other kinds of intellectual property. But I'm not able to answer them. I want an expert to answer them. So thank you so much, Sharon, for being here. For being here 8 p.m. on a Wednesday to talk about the fascinating world of intellectual property. How's it going, Sharon?
Of course. Thank you so much for having me. It's going great. I'm excited to be here.
Sharon, I find the topic of intellectual property really fascinating. I personally do. Not as much as employment law, but intellectual property is something that I always enjoy the class, in law school. So tell us a little bit about, for folks who are out there, who are about to open their business, who have an idea, what sort of intellectual property should people worry about? Give us an overall view of what intellectual property is out there for folks to even think about.
Okay, definitely. So when someone's starting a new business or has a new idea, the first thing they do is they ask us, do I need a copyright, a trademark, or a patent? Those are like the three main areas of intellectual property. So
are there other ones though, Sharon?
Yeah, they're trade secrets, trade dress. Okay. Those come very specific to a particular business. I would say the main ones, just to start, especially if you're starting a new business, would be copyright, trademark, and patent. So we like to explain the differences between the three. A copyright protects an original work of authorship. That's like a book, a poem, a piece of art, a musical composition. A trademark protects or distinguishes a business or a brand from another. So if you're looking to protect your business name, you would actually go for a trademark, not a copyright. A patent, on the other hand, are for inventions. They're sort of like a license from the government that give the inventor the exclusive right to use their invention or to license their invention or to sell their invention. That could be like a vaccine, for example. It gives you incentive to create this vaccine because no one can steal it from you for a specific period of time. So the next question we usually get, when we have someone who says, should I register the copyright? Should I register a trademark? Both of those, you have inherent rights. So a copyright, you inherently get a common law copyright the minute the work is created. A trademark, on the other hand, you start to get trademark common law rights once you start using that mark in commerce, and you have to have some continuous use. So those are like kind of the three main areas. And, like I said, you get a little bit of protection just by using them. We always recommend when someone's looking for a trademark to get it federally registered. And the difference between a federal registration and a common law right is your scope of protection. So when you just have a common law trademark, you've just been using it, you didn't register it or anything like that, you're very limited in your geographic scope. So if I'm selling just in Brooklyn, I'm really only protected in Brooklyn. But if I want to be protected throughout the country, I would look to register a federal trademark. And we suggest that new businesses, sorry.
No, I just was wondering.
Yeah.
And I'm sorry, I think I have a lag now. But go on, Sharon. I didn't mean to interrupt you. Go ahead.
No, not at all. We just suggest that new businesses go for that federal registration because it stinks when you put in months or a year's worth of time building a brand and a business, and you find out down the line someone else already has a right to that mark. So we always like to suggest that that's one of the first steps you do is a trademark search and registration.
Got it. Can you give us some, for people who don't know, what are some examples of trademarks? Let's talk about some like well-known trademarks. So
sure. So a trademark could be Nike or Google or Gucci. We kind of think of them as like the brand names. It could also be a logo. So the Nike check mark is also a trademark, or the little symbol of the woman on the Starbucks cup.
Got it. And why is it important for people to think about? So when you first think about a business and you think about an idea and you think, oh, this logo could be really cool. And so, for example, you want to name your name is Victor and you want to name your businesses, Victor's Secret, for example.
Right.
I think that's an actual case. So Victor's Secret, right? That reminds us of Victoria's Secret, right?
Exactly.
Would that be a problem for a Victor to have that trademark?
So it depends. We have to see what Victoria's Secret is registered for. So we definitely know they're registered for clothing, for lingerie, maybe for a few other items as well. Now, Victor's Secret wants to register for anything similar, he likely can't. However, if he wants to register for salt and pepper shakers and Victoria's Secret's mark doesn't cover salt and pepper shakers, there's a chance he can get a registration for that.
Got it. And why should people even think about it? Well, should people that want to open up, for example, a bakery in Astoria, should they say, can you open up a business? And by the way, I also want you to trademark this. Why would they do, what's the incentive for them to do that?
So the goal of trademarks is to prevent consumer confusion. So when you're building a brand, you're also building up the goodwill associated with it. So what's stopping me from making Coca-Cola in my bathtub, putting it on a bottle? It has no FDA approval. It hasn't been checked. I'm making it in my moldy bathtub. I'm slapping that Coca-Cola symbol on it and I'm selling it on the street. If someone gets very sick from that, they're going to sue the real Coca-Cola company, not me, and it hurts their brand in the end. So they're able to prevent me from doing that.
Got it. So it would prevent anybody from, say, selling shoes. Actually, this is a big issue, right? People who are selling fakes with the brand, without, for example, Louis Vuitton. Let's talk about a big brand, a big trademark. I'm sure Louis Vuitton is a trademark from selling anything that is not licensed by them, right?
Right. So Louis Vuitton has spent years establishing their goodwill and their consumer base. So we know when we buy a Louis Vuitton product, it's coming from good quality and it's real. It's not someone who is using a fake leather. It's going to fall apart right away. It kind of prevents this confusion and it stops others from hurting the goodwill that they've established.
Right. But it still happens a lot, doesn't it?
Yeah, it happens every single day.
happened the other day on, Broadway downtown.
Oh, yeah.
And so we've talked about copyrights and trademarks, right? So let's talk a little bit about copyrights. Who are the people that should get copyrights? Like what business should be out there getting copyrights, or is it just for creative types that want to protect, a song or Tell us a little bit about the difference between those.
So we find that a lot of the people who get copyrights are the creative types, because it's if you've written a book or you've created a piece of art or a musical composition or a poem. So that protects, that piece of work in a whole, not just the title of it. It protects the whole work itself. So we don't want people, the same way you don't want them knocking off the brands, you don't want them knocking off your characters that you've established, or the poem, or something that sounds very similar. An example would be to write a play and use the Grinch as your main character. Dr. Seuss has a right. They've created the Grinch. When we hear the Grinch, we identify that character with Dr. Seuss, and they've worked hard to market and create that character. So it wouldn't necessarily be fair for someone else to now kind of ride their coattails and use it.
Right, to steal an idea. So if you say, for example, you write a children, so let's talk about, if we're talking about the Grinch, let's say that you're writing a children's book. Is that person automatically protected? Is that work automatically protected, or does the person have to actually do something to say this is my? Because I feel like now in the internet, anybody can copy anything, right? Like you never know like what's what, and you're like, well, this person really, or you like package ideas in different ways that you don't really know, what you don't really know what's what sometimes on the internet, And so how do people? So say for example that you're writing I don't know, you're a blog writer or something. Is that protected? Like, are you on the internet protected from having your own blog not stolen?
Yeah, so the minute you actually create the work, you have a common law copyright. It's created upon creation. However, if you end up wanting to sue someone for it, you have to actually have a copyright registration. That's how you're awarded statutory damages. So we recommend registering for the copyrights as well as sort of a preventative measure. While, trademarks we do from the offset to start the growth of the business, the copyrights are almost for the other side of it, to prevent you from getting sued or for allowing you to sue someone down the line.
Okay, so the difference is if you have never registered your song, your book, you cannot sue somebody and then get damages for having that infringed.
So you can to an extent. You can't get statutory damages.
Okay, which I'm sure are much higher, right?
Yes, yeah, treble damages. About 3 times.
Treble damages. Mm-hmm. Got it. And so I have a lot of friends who are photographers, and they sometimes, get their like a picture used or something. Actually, here's a better example. I had a case where it was a real estate office where somebody was stealing pictures, like real estate agent was stealing pictures from other websites. And this person actually took this other agent to court because he was using his apartment pictures. And everybody was baffled because I'm like, well, it's the same apartment, right? But it's not the same picture. So how do you, and this person never registered those pictures. How was that person able to sue the other broker for using his photos?
So that's
this is for all. This is for all my broker friends who have asked me the same question. I hope they watch this answer.
So that's the benefit of a copyright, right? You're getting some protection the minute you create that work. So the minute you snap that photo, you do have a level of copyright protection. And that's why you are able to sue people right away for it. You would just get, more protection and more damages if it were registered.
Got it.
You can register those photographs at any point. You don't have to do it the minute you take it. You could actually register it right before you start the lawsuit.
Got it. Yeah, I don't think that real estate brokers are in the business of registering their photos, but this was actually a federal case, which everybody. My friend was actually the infringer. Mm-hmm. He was the one that took the photos, and he just couldn't understand why this happened, and so on and so forth. But it's very good to know. So you own the photos the minute you take them. It doesn't matter whether you're a real estate broker taking pictures of apartments. You own the copyright of those photos.
Correct.
So that's great to know. And I'm glad I thought of that example because it's a great example of how look, you do have protection, and you should also be really careful of using other people's stuff, right? So it absolutely goes both ways. Can we think of any other examples where people, could register? So we have the creative types, but we also have photos that are put on the internet. What about if you have stuff on your website? So this is also a question that comes up a lot, Sharon. You have something on your website and somebody recognizes it as their photo. They're like, that's my photo. And then they slap you with a demand letter, a cease and desist letter saying you're using my photo, right? And then maybe you stole it from you took it from somewhere else and you don't know. How do we, is that something that you see happen every day?
Yeah, so that's something we see a lot, and it really depends on the website where you get the photo from. Some websites actually allow you to use the photographs. It's in their terms of use and in their share policy. So if I'm a photographer and I'm uploading photos to a particular website for other people to use, there's certain rules in there in certain websites where they are actually allowed to use them. On the other hand, there are websites where they're not allowed to use them. And we try and advise our clients, if you're getting these photos from the internet, you need to read the information or at least send it to us to vet first and let us confirm that you actually can use these photos for your website. A lot of the time, the website itself retains ownership. Automatically when I upload the photo, I assign my copyright over to this website. Other websites allow you to retain them. And they just, pay you a fee to license those photos out to other people. It really depends on the website itself. And we see that popping up a lot because there's new websites coming up every single day that allow you to use photos.
Right. Very interesting.
Yeah.
So we have an understanding of trademarks, right? If you have a business, you should talk to a lawyer. And if you have a trademark, and if you have a logo that you want to protect and you don't want anybody to use,
that's a trademark as well.
You could probably trademark it. But if you don't trademark it, you also have protection, correct? If you don't
limited
trademark
protection.
your logo.
Yeah, you have limited protection. So if I'm only using my logo in commerce in Brooklyn, someone can actually come up with that logo in California and register it, and they could probably get a registration, and they could stop me from using it anywhere other than Brooklyn, where I've already used it.
Got it.
So I only have rights in that little area.
Okay. So when you open a business, guys, an LLC, PC, we've talked about this in past shows. It's always a good idea to talk to not just your business attorney, but somebody like Sharon, who specializes in intellectual property, to discuss, how to protect, not only how to protect yourself and your business by having a corporation, but also protecting your brand. Copyright, a different thing. So now let's talk about patents, right? Patents are a completely different monster.
Yeah.
And they are all about inventions, right? Inventors.
Yes.
So who would need to patent something? Just people who come up with ideas that.
Yeah, so you have to, it has to be a patentable idea. It could be a process. It could be a design of manufacture. If you create a physical object, I think we see that on Shark Tank a lot, if you're familiar with the show, where people come up with physical objects. And the first question the sharks ask is, do you have a patent? Because they want to know that nobody else can knock off your idea. So that's the benefit of getting a patent.
Got it. And how is it difficult to get a patent?
It is. It's difficult. The type of people that register patents have science degrees and science backgrounds, because there's a lot of technicalities involved in it. And that's why it's very important to see a patent attorney if you have an invention, because they can really walk you through it and kind of handle the very difficult side of it. But because it's so difficult to get one, there's a lot of value in having one.
Gotcha. So Sharon, you mentioned before, so we were talking about the three main areas of intellectual property, right? But you mentioned one that is particularly interesting, which is trade secrets, right?
Yes.
So trade secrets, it always makes me think of Coca-Cola, right?
Yeah.
Like nobody knows what Coca-Cola is really made of.
Exactly.
who knows what you're drinking when you drink Coca-Cola. It's a trade secret, right?
Mm-hmm.
Is that something that you come across a bit? People stealing, like, a trade secret in everyday life. So, for example, an accountant or something. If you're working for an accountant and he has a method of doing things, is that something that you come across a lot? People stealing secrets from their employers, or is that just in the Coca-Cola world?
Yeah, so trade secrets are a really interesting area because we don't register those, right? Because we don't want anyone to know them. The secrets are very tightly held by only a few people. Even in Coca-Cola, there's only a handful of people that really know that recipe and how it's made. So the goal is to just keep that protected, and a trade secret stays a trade secret until it's found out by the world, right? So we do have situations where people steal from their employers. Anything could be a trade secret. If you have a unique way of doing something and someone in your business has access to it and gives it to someone else, they've stolen the secret. So it's definitely something that we see, and we see it very often because people don't realize what's really considered a trade secret. Like you said, we think of Coca-Cola, we think of Doritos, that special powder on the Doritos that gives it its flavor, but it could be just, in an accounting firm, in a law firm. We see it with Uber, the specific routes they take to pick people up. Those are all trade secrets.
Oh, is it? Oh, we didn't know that. It's really interesting.
I also didn't know about the Doritos. Their routes.
Wow. And I also didn't know about the Doritos things, but
we see it a lot in food for sure.
Got it. Wow, that's really interesting. So when thinking about, I was hoping to talk to an intellectual property attorney because I want to be able to answer the most common questions, right? Of folks, just everyday folks that are wondering how to move the business forward. So, what are some of the common questions, Sharon? Because I'm sure that I'm not even asking you I'm just touching the surface here as far as like what could be important in intellectual property. As an attorney, what are some of the things that you come across that that can really, really, that maybe like a worst case scenario, or how can people really protect themselves with just speaking to somebody like you when they want to open up a business, right? Or a lot of people are opening up, people opening up a restaurant and they have a recipe, for example, right? Like they're opening up the delicious, whatever, Greek food in Astoria, and they're like, I have the recipe that nobody else has. Can I protect it, or something like that? Like, is there anything else that you can think of that comes across in your line of work as you advise people, right, about their IP rights?
So I think the thing we see most commonly, especially for example, like the restaurant business, is mostly that trademark factor. Because people use very common words for restaurants, like so-and-so's pizza. You can't register a generic word. I can't get a trademark for pizza because I can't stop other people from using that word to describe pizza places. So we find that a lot of restaurants or bakeries, especially if there's any type of cultural affiliation, they try and use very similar names, and we always try and advise them not to. We think the most unique name you can come up with is going to give you the best level of protection. And that means not using a generic word, not using a person's name like Pete's Pizza. You can't stop someone from using the name Pete, and we can't stop someone using the word pizza. So we find that that's like the biggest thing we advise about, is try and find a really unique name for your business. That's just going to help you. And then the next thing is a lot of people think that they get protection because they've created an LLC or a corporation. Just because you've created an LLC or a corporation doesn't mean you have a trademark. So it's important, to make that distinction clear.
So Manuel is showing us here something from the PN website that's really interesting. Check this out, guys. Domain names are important to how you brand yourself and define your business on the internet. Very true. What if you don't? So obviously a lot of, look, I'll give you an example. My website, Fight for Your Rights, right? Fight for Your Rights. I couldn't get the actual Fight for Your Rights. It was $25,000. So I got Fight for Your Rights. You are rights. Right. And by the way, a judge called me out on it one time. He's like, do you realize that your website is misspelled? I'm like, Your Honor, do you want $25,000 to give me? Because then I'll get the real website.
Yeah.
This actually happens. So, for example, domain names, right? You get a domain name. You're hoping to get the best domain name for your, for your business. You get everything that you could possibly get with your name on it. So like Susie's cookies, Susie's cookies or something. And then you can you trademark? Is there anything that people need to know, that folks need to know about the actual domain? Like, is that something aside from owning the domain? What else do they need to know? Because I think that's really, really important.
So you can definitely trademark your domain name as well.
Wow.
If your domain name is something like Fight for Your Rights and you already have a trademark, Fight for Your Rights, there's a chance you might not necessarily need it. But we do have a lot of clients that elect to do it. I think the bigger issue we see with domain names is this idea of cyber squatting. People, prowl the internet. They see these businesses starting up. They quickly buy up the domain name. And then when the person tries to buy it for their business, they charge them a crazy amount of money, more than even $25,000. That's actually illegal. You can't do that. And it's funny because I hear people in the street kind of make jokes about it. It's like, oh, this new restaurant's opening up. Let me buy up their domain name because then they're going to have to buy it for me. That's actually illegal. So people get sued for that all the time. Yeah.
Oh,
it's almost like trolling. It's different. Did that person, buy up that name because they knew you were looking for it, or did they already have it and it was just a weird coincidence? It depends.
Right. I mean, I like to think that it was a weird coincidence for my own personal thing, but I did manage to get the Fight for Your Rights in Spanish with the proper spelling. So that's okay.
That's a win over there.
That's a win. But you're blowing my mind right now, Sharon. I had no idea, honestly. I had no idea that you could trademark website, domains. That's really crazy.
Yeah.
Wow. That's really, really good piece of information. Okay, so you can trademark your website, you can trademark your logo, if you're gonna if you have like a recipe for cookies, then you can.
You should keep that as a trade secret, and you shouldn't tell it to anyone.
Got it.
Don't post it on the internet. Don't tell your family. That's your trade secret.
Right. But what about the people that are making cookies and they don't know how to make cookies? Do you have them? Do you have your employees sign something ahead of hiring them? Like, hey, listen, here's my cookie recipe, and if you do something with this recipe, here's what's going to happen to you.
Yeah, so we actually handle that for our clients a lot. We write non-disclosure agreements, and we encourage our clients to have them sign it, have an employee sign it before you even discuss a thing with them. And confidentiality agreements as well. We do like a combo of an NDA confidentiality to make sure that it's not being discussed or shared or spread.
Got it. Okay, and so what happens if that employee opens Bob's cookies and you're absolutely sure that he's using the same recipe? Is there any way to prove that? Like, hey, Bob over here who worked for me for 2 seconds just got a hold of my my cookie recipe. What happens there?
So there are a lot of factors, but if someone had access to the trade secret or obtained it improperly, like they stole it, then you can sue them 100%. But if I'm on the other side of the world and I just coincidentally came up with the exact same recipe and it tastes exactly the same, I've never tried yours before, I've never heard of yours before, then unfortunately the trade secret's out, or we both hold it and we don't tell anyone and we agree to, kind of both keep this secret.
Right. Awesome. So you wouldn't get a trade. So I just want people to understand, you wouldn't get a patent for a cookie. You would get, just make your cookie.
And hold that secret to yourself.
Okay. Yeah. And for patent, if you have an idea, so I assume same thing happens if you have this great idea for a gadget. You think invention, necessity is the mother of invention, right? People invent things because there's a need, right? They found that they needed something, and then they have this great idea of how to solve that problem, right? And patents serve to to encourage that, right? To encourage creativity and to encourage people, because if you're inventing something and you couldn't profit if you couldn't profit from it, people wouldn't have the incentive, right? They just would be like, well, what the hell is the point of inventing this if I'm not, I'm just gonna.
If someone could steal it the next day, exactly.
Right. People are not people want to get rewarded for their creativity.
Right.
But I lost my train of thought. So patents. What happens if you're just, Susie, who has an idea? Who do you go to? Do you go to your lawyer? Do you say, I have an idea, I'm going to go to a lawyer? Who is the first person that you would talk to if you have an idea? Is it like
so you want to
somebody
see
that could make it?
So you want to see a patent attorney right away, because depending on so many different factors, very unique to each situation, there's actually a timeline about when you can apply for the patent. So if you come up with this idea and you present it to a group of people, all of a sudden there's a clock that ticks and you have to apply for that within a very specific period of time, or else you can no longer obtain the patent. So what we tell our clients is, the second you have an idea, don't spread it to anyone. Don't even tell your family members. It's not worth it. Go see an attorney first. Let them make it clear to you what your timeline is for applying, and get that started before you start spreading the word. We find that a lot of the time people come up with these inventions and they want to go to trade shows and they want to show it and display it to people in order to raise money. But then too much time runs out, and it's in certain situations, it could be a matter of months. And because they displayed it and didn't apply for it within a matter of months, they've now lost the opportunity to get a patent. So it's really important that the first person you speak with is a patent attorney.
Amazing. First person to talk to, call your lawyer, even if it's not even if I'm not a patent
they'll
attorney.
refer you to one. They'll refer you to one.
I know.
There's so many different patent attorneys. If you invented some type of medicine, you want to see like an attorney that's a biochemist. But if you've invented a cool new way to put on shoes, you want to see someone who maybe does like more mechanical engineering.
Right. That's very important. Yeah.
Yeah.
Because patents are, patents can be, formulas, chemical formulas, right? And patents can be like an object that you invent to make to make life easier.
They could be apps on your phone, programs on your computer.
Right. Sharon, I don't understand the time issue though in a patent. So you're saying that you go to your wife, you go to a trade show, and there's a certain time that you have to file a patent. What is the time, and why is it important? Is it some sort of statute of limitation that people have to be aware of?
Yes, and it's very specific for each type of patent. So let's say I create something and I now go to all these trade shows for years. Someone eventually is going to get a hold of my idea and they're going to apply for that patent. It's not fair that I have this exclusive right for years and years and years before I've even filed. The idea is, you have this idea right away, let's go and protect it. This way you can start creating it, manufacturing it, and selling it. And you can begin preventing people from using it. We can't really prevent people from using it if you haven't registered it yet. And it's not fair that I get to run around the world showing it to people for years to come before I even go and register it.
I guess that would make sense to me.
Yeah.
This is all fascinating to me, Sharon. Thank you so much for being here again and for talking about this. Is there anything else that we could tell people about how to protect, what happens in a business? So trade secrets. I love that we talked about trade secrets for cooking.
Yeah.
I'm sure that we have trade secrets for like drinks, right? For cocktails, how to make a cocktail. Although I'm sure, some stuff is like really easily reverse, like you can reverse engineer some stuff and figure it out, right? I'm sure that has a lot to do, like, oh, let me just, you don't want to tell me how to make this drink. I'm gonna reverse engineer it or taste it or whatever. But I'm sure it happens too, right? There's people that have drinks and they don't want to tell anyone else how to make it because it's a money maker for them,
right?
And they don't want and they just don't want to share it with everybody else. But oh, look at that. So you guys do domain name disputes. So art disputes, I'm sure it's a big one. Well, art is a little bit more interesting, right? Because if you have an art piece or whatever, that's I once had a case a long time ago when I was in law school. I interned for this guy who was an art lawyer, and his clients would get slapped with cease and desist letters from like Woody Allen, this woman this girl made some pillows with Woody Allen's face on them.
Yeah.
And of course you can't do that, right? And why can't you do that? So let's talk a little bit about name and likeness, right?
Right.
Why that's an important one. Why wouldn't you be able to slap Woody Allen's face in a pillow and sell them? What is it to Woody Allen,
Well, it's a lot to him. He doesn't get to see any money from that. You're making money off of his face, off of his likeness. I mean, we see that in our law firm every day. Yeah.
I was being facetious, by the way.
No,
but
I
want
know.
people to get the point. Yeah.
Yeah, I mean, that's a big issue we see in our firm. People go onto Pinterest, onto Etsy, onto Redbubble, and they create these items using celebrities' likeness, and it's actually illegal. And, you can get sued any day of the week. They don't care if you're 7 years old or 70 years old and you're creating these stickers. You're going to get sued if you're using someone's likeness or their image without their permission or their name to even advertise it.
And I'm sure you can go and like get their merchandise, right, and go and confiscate it. That's the thing. Like if you're making pillows with Woody Allen's face, I'm sure his lawyer will call you and say, hey, first of all, stop it, cease and desist from doing it, and then second,
send us your accounting. Let's see how much money you made off of it. Not only do we want all the money you've made from it, we want to collect our attorney's fees and we want damages for having to go through the steps. And we do this a lot. So you think you're making like a couple $1,000s, maybe at most, selling stickers. You're probably going to get sued for a lot more than that. So it's a risky business to enter, but people look at it as a quick way to make a little bit of money.
Right. Wow, that's really interesting. Yeah, a lot of that goes on. Actually, Tasso was telling me about that basketball player, the Greek basketball player.
Yeah, so we represent a number of basketball players at our firm, and we have this issue a lot where people go online and they make these phone cases and stickers with their face on it or their name on it or their registered trademarks on it. And unfortunately, we have to send them those cease and desists and sue them for it.
Right. I do remember going to the office and seeing a bunch of
confiscated
Greek. I actually think I have one somewhere on here. That's really fun. So anyway, guys, be very careful if you're going to open a business. Make sure it's not using a celebrity's likeness or anyone,
or any trademarks. No Disney characters, anything like that.
That's an interesting one. Disney characters, right? So Disney characters are forever protected, and they're never copyrights. Oh yes, so let's talk about that. So copyrights never really lose. Is there an expiration date? So I'm so you have Mickey, right? Can you use it forever?
It's weird. So a piece of work that was created after 1977, your copyright lasts for 70 years after the death of the author. However, there's many ways to slightly modify these characters in order to get new copyrights on them. So that's how we see Mickey through the years. The first Mickey looks very different than the Mickey that we see today. And they do that to kind of continue protecting the characters.
Yes, the original Mickey had a very different nose. I have noticed that.
Yeah.
Wow, that's fascinating, Sharon. So the purpose for that is that original Mickey, that trademark. So that means that the original Mickey you could probably use, right?
Yeah.
Replicate and use, right?
Don't
like the original one.
Don't quote me on it, but yes, that expiration would likely be up.
Okay.
I'd have to check the date that it was created.
Right. But just for folks to know, it's 70 years. So if the first Mickey that Walt Disney drew and it's protected, I mean, this is way over 70 years. But then you're
70 years after death. So if you die at 25, it's 70 years on top of the 25 years. If you die at 105, it's 70 years after that 105 years.
Okay. Got it. Okay. Wow. That is really, really fascinating. That's really fascinating stuff. And I hope that folks out there who are watching this are finding it as fascinating as I can, because that really explains the reason as to why, if you think about it, a lot of characters have changed, a lot of things.
Yeah.
What about things like, so let's talk about pharmaceuticals a little bit. I don't talk about like to talk about pharmaceuticals, but it's important. So penicillin was invented, I don't know, a long time ago.
Yeah.
Who knows? Penicillin, right? So somebody invented penicillin. I'm sure that person got a patent.
Yeah.
Is penicillin available for anybody to market today as penicillin?
So
or
not the name penicillin, if the name penicillin has been trademarked, but the actual ingredients itself, depending on the patent, patents on average have either like a 14 or a 20-year lifespan, depending on the patent. Once that patent expires, that's when we see those over-the-counter versions, or we see the generic brand of it. All of a sudden there's a generic brand for all of these drugs. That means the patent expired, and now people have the ability to make that, and usually at a much cheaper price, because there's no more exclusivity. A lot of people can make this drug now, and in order to stay competitive, they have to bring the cost down for consumers to purchase it. So that's why when a drug is new, it's often very expensive, because there's only one. Once you see those, generic brands, it becomes a lot cheaper.
Right. And we've seen that, right? We've seen that happen recently with like all the names of price, brands going up and people having a fit about it. But and that is why we see now, I'm sure, Tylenol, for example, right? The CVS version and the Walgreens version and this version and that version. Because
they've made their own versions because they can now. Right.
And so I guess the justification for that, sort of like the explanation for that, why that is, it's because, I mean, it serves as it serves a purpose for the public, right? Like you don't want to have people pay so much money for these drugs forever.
Right. And we don't want them to create these monopolies where like they can wake up one day and say, okay, nope, Tylenol costs $500 now. And if there's no alternative, people are going to be forced to pay that. So, we're giving you a little bit of time to create this exclusive drug because you've worked really hard, you've invested time and money, but at a certain point, we're going to stop you and we're going to let other people make it as well to kind of continue driving that innovation and competition.
Right. So make your money now because you're going to lose your patent in however
Right.
years. That's awesome. Wow. I've learned so much, Sharon, today, and I hope that folks have learned as much, because I could go on and on and on, but it's already 8:48 and I know it's late. And is there anything else, Sharon, that we should tell people about just the general concept of, and thinking specifically about business owners, people that are just starting to own, think about forming their business, become their own bosses. I don't know if you heard about this. The Great Resignation is coming up, or it is happening right now, where people are like, I don't want to go back to the office. I'm just going to stay home and have my own business, whatever. And that's great, but there's so many things that you need to think about, all of these things, all those intellectual property that people usually, don't think about, like we were talking about the fact that a lot of people are, a lot of people are just not, are opening up the business without opening up a corporation. And and there's a lot of them because they just don't know. They don't know that
they just don't know. Exactly. I always say, most firms, I know our firm will do it. Anyone can get a free 30-minute consultation. Call us on the phone and say, listen, this is my business. What do you suggest I do? And we'll let you know. Open up an LLC. Let's trademark this. Hold off on this. Let's get you an NDA because you have, some secret recipe. And we can advise you on what type of items we think you need. And we can tell you the cost. We can work out a plan to let you know which order you should do them. This way you can kind of spread the costs out if you need to as well.
Right. Very nice. So, Manuel, can you show us Portales and Novica's website and a number that they could call? I mean, I could hold on. It's PN Lawyers. There you go. So it's PN Lawyers.
212 313 in the corner.
Yeah, and you guys have a place in Manhattan, and you guys have a place in Astoria as well, where people can go and have, in-person phone meetings. I'm sure you guys do Zoom meetings as well.
Yep, Zoom meetings, phone meetings. We're on Long Island as well.
Awesome. Sharon, thank you so much. I so appreciate your time today. I'm completely mind blown by all the information that I didn't know, that I need to know, that I'm sure people are going to be very happy to learn about as well. And again, guys, Sharon Khan from Portales and Helvica, intellectual property, really, really important stuff. If you're starting your business, I know we've talked about, our Facebook Live on corporate formation was one of the most popular ones. People ask me about it all the time. I don't do corporate formations. I don't do any of that, but I do know lawyers who do it, just as I know lawyers like Sharon who specialize in intellectual property. So if you guys want to talk to an intellectual property attorney, please call Sharon. Anybody at Portales and Helvica will be able to help you. Thank you again, Sharon. I'll see you guys next week on another episode of Charlas con Lina, where I'm sure we'll talk about another interesting subject that I haven't thought about yet, but I will. So thank you so much. Thank you, Manuel, and take care, everybody. Have a great night, and thank you, everybody out there, for for being here. Good night.